So, remember I asked you, what is the environment? So what is a court? What is the environment? I'm going to ask the woman in the red. What is the environment behind you? Behind Alex.
So the environment is everything that surrounds us, which is like trees and the marine life and everything that's natural.
Okay, good, that's wonderful. I'm going to have the next couple of women add to it. What else would you add?
Nature in general, at least in this context.
That's what?
Nature?
Nature? What do you mean by nature? Okay. Air?
Yeah.
Okay. Land development? What about you?
Yes.
Okay, so if you were designing an environmental court, would you put all of that under the court's jurisdiction? So interestingly enough, in Hawaii, our legislature did not do that. They decided to take certain things out of the jurisdiction because of political considerations. So let me try to mention a few of the issues involved here, where we are now, and then I'll try to finish up. So from the very beginning, the judges said our goal is to change behavior regarding the environment, not necessarily to punish people or to impose fines, but to change behavior. We're a small island, a small community, and we need to really reduce the number of violations. So already in the first year, we've been working with the court, the law school, working with the court to increase the toolkit for the judges. Again, a design issue. What tools do you give your judges? Injunctive relief, declaratory relief, criminal penalties. So here are the things that the court has asked for that we've been working with them on. One is to take certain small cases and dispose of them administratively like a traffic ticket system rather than go to court. So what is your name? You're at right here. No, the second one here. You. Next to Christine. What is your name? Harsh. Okay. So if you are out and you're an enforcement officer and you see somebody fishing illegally and they have a pole and they're fishing in an area where they shouldn't be fishing, and the only thing you can do is to impose a criminal penalty on them. What if it's the first time this person's ever been fishing in their life? Do you think a criminal penalty is the right approach? How would you handle that?
Not actually, because if he's fishing for the first time, he might not be knowing that this is an offense.
So this is exactly the problem. We have a lot of military visitors, we have a lot of tourists, they come to Hawaii and they say, I'm going to get a fishing pole and go put it in the water and fish for the first time, or people who are ignorant of the law. If your only tool in the toolkit that you give a judge is a criminal, and that's the only choice you give a judge, then this person is forced through the criminal system. It's quite shocking. So we're developing this kind of administrative ticketing system. In addition, we worked on legislation in 2016 last year to give the judges an option of sentencing the individual, whoever Harsh has nabbed in the protected area, to an educational course, or to community work service, make them go work in the environment that they were impacting. So there's been major collaborations ongoing and conferences. The judges have been very much on board in trying to, again, this is a design issue, giving judges the toolkit they need. The collaboration internationally has been growing. This is a picture of the bill that was signed last year, and if you just take a look at the picture, do you recognize some of your distinguished Indian leaders who are in that picture? On the far left, you just skipped out of the conference here, but there's your dean, and then Justice Kumar, Justice Sikri, and then in the middle, holding that portfolio, is our governor of the state of Hawaii, David Ige, and then Chief Justice Tukur. So, and then some of our distinguished leaders who were involved in creating the environmental course. This partnership is very real, and it's still a work in progress. I want to embarrass our student, Christina Lizzie, who's here with us today. She's also a big part of this story. In 2015, and for law students in the room, I just encourage you to take advantage of every little opportunity. You never know where it's going to lead. So when Justice Kumar came in 2015, I asked for students, who can host him? Who can go on a driving tour with him and his wife? And Christina volunteered. And look where she is now, working for him at the National Green Tribunal. Then we had this India-Hawaii Symposium in 2016. She was an incredible organizer and devoted countless hours to helping me pull that off. Was a member of our voting delegation at the IUCN, where we had 10,000 members from around the world participating on environmental law issues. Now she's here with you and sharing the spirit of aloha and recruiting for our law school. Then she'll be, I hope, working with us at the World Commission on Environmental Law and then clerking for Justice McKenna. So take advantage. I know you will. I know you're by your being here, you're taking advantage. So just a few more things, the challenges ahead for our court. Remember I said the purpose of the court was to try to get consistent and uniform application of the law. And again, that's a design issue. You want law to be just and fair, but very difficult to do. One of the things we're trying to do, working with the court, we at the law school don't have the power to do anything but to support them, is to try to consolidate those environmental cases on the same days. Some of them are already designated. So, for example, I call it Fish Friday. So you know all the fish cases are going to be on Friday. If you're the judge, it makes a lot more sense. You see all the fishing cases together instead of a domestic violence case next to a fish case. Because if you put those side by side, natural human instinct is to not give it its due. So we're trying to actually design the docket so that is more uniform and comprehensive.
Can I just add to that, the Supreme Court of India used to have the so-called forest bench on Fridays as well.
Yeah, Forest Fridays. Okay, thank you.
For about 20 years.
It makes a lot of sense. And it's harder to do, it's a work in progress. We also had a political attack on our environmental court last year, where our legislature pulled certain cases out of the environmental court and listen to this as a design issue, took those cases and gave them right to my colleagues here on the left, right to the Hawaii Supreme Court. So for example, certain very important public utilities issues, which are energy law issues, contested cases, administrative appeals, Water Commission now go straight to the Hawaii Supreme Court, so I won't comment on any more about that, but that the legislature stepped in for political reasons, in my view, and redesigned jurisdiction. There's no resources, we're still in the progress of adding to this toolkit. So challenges ahead, we're still trying to figure out how do we measure progress on this very new court, how do we share statistics, how do we analyze them, how do we tell the stories of the cases, how do we provide law clerks or support through law fellows, strengthening the chain of enforcement. We've created a friends group, an external group of friends to support the court. We haven't really activated it yet, but every court needs friends. And we're trying to, I think, expand this model to other US states and to encourage them to explore that. So opportunities, we have great judicial leadership on this issue. We are undertaking a lot of training despite the lack of resources. We're working on jurisdiction. One small bill that we're working on now is literally to take the parking violations out of the environmental court. So if you go, I'm not going to call anybody, but if you go park in a state park and you get a parking violation for your meters run, you would go into the environmental court and be charged with a criminal offense. Doesn't make sense. It's clogging up the courts. So again, these are design issues that the legislature didn't think about.
Is this maybe deliberate?
No. No, I'm afraid not. On the other hand, the bill that we're working on says if the parking violation is related to the environmental crime, which it sometimes is, then it stays in, right? So if you park in order to commit environmental crime, it makes sense to stay in. But if you're parking because you want to go hiking and your meters run, it shouldn't be an environmental crime. So we're continuing, as I mentioned, conferences, symposia. We're working on a report for the judiciary because right now the judiciary doesn't have the resources to even report to you about how the court is doing. And that's my last slide, just to say that I hope this partnership continues. We are very proud to fly the Indian flag at our law school alongside the state flag. And so we say aloha and mahalo, which means thank you for this continuing partnership. So I hope that sparks some ideas that we can talk about later in terms of how you design courts, environmental systems to deliver justice in whatever area inspires you. Thank you. Mahalo.
Thank you so much. Now the question is whether we have the break now and then continue after the break with the panel, or whether we continue the panel and...
Just continue the panel perhaps.
Yeah? Continue the panel? Is that all right? Okay, but I would suggest that we have the question and answer then at the end of all the presentations, yeah? So that we save a little bit of time and don't get lost in a specific debate to a specific panel presentation. So it's my understanding that we now move on then straight away to Justice Wilson. Yeah? Thank you.
Thank you, Alex. I do have a PowerPoint, but I'm only going to take 5 minutes or so since I was rather long-winded before. But I would I'd be interested in deferring to you, Armin, if you want to go next, because I want you to get the time you need, and then I'd be able to kind of listen to what you have to say, which is part of the reason I'm here. So do you want to go next?
Okay.
Good.
Okay, well, I'm the only kid on my block that doesn't have a PowerPoint.
Don't forget to use the microphone.
I'll talk, the judiciary, which had earlier mentioned interlinking rivers, and interlinking rivers is an idea who I think was heard by one judge from his son-in-law. This is my reconstruction, it may not be true. And the son-in-law told the judge told his benchmates, and the three of them told three others, so you have 9, and they told 3 others. I believe that there's hardly a state in India that wants to share its rivers with anyone else. If anything, rivers are scarce, water is scarce. Tamil Nadu is the only state that might want it because it's very scarce in water. So, and plus you'd have all these transboundary issues. You know, the Indus River is the border river between India and Pakistan. The Ganges Brahmaputra forms part of the border in Bangladesh. These international rivers, nobody even thought about what do you do with international rivers and with transboundary water issues. So this is all on the court's own motion, suo moto, the court's own motion, which has gotten them into a fair amount of trouble elsewhere. The international river linking case is the one that is the nearest, but they've also been involved since 1995 in what is called the Godavarman cases. The Godavarman cases are still going. They have something called a continuing mandamus, which has allowed this issue to come up again and again over the last 22 years. Hardly a week passes by when someone doesn't have an issue about the Godavarman case, because what the court did in the Godavarman case, it declared all of India, this was just a case in a small neighborhood, the forest rights of a small neighborhood. The Supreme Court of India decided India lacks adequate forest cover. So we are going to require all forest covers of India to be controlled by us. And the first thing we're going to do is no tree felling anywhere in India. Now these are major operations. They didn't foresee that all of the Northeast is, not all, but a good portion of the Northeast occupants are in the wood trades, forest trades industry. So there was a huge amount of unemployment in a very underemployed region of India, the Northeast. The Delhi pollution case, another case where the court decided to take it on its own. Now there they were lucky because they discovered compressed natural gas as a driving fuel for vehicles as an alternative to gasoline, and that has worked. The only question is, what did they, by doing that, they essentially inhibited the growth of appropriate institutions in the executive branch to manage air pollution in India. The court was taking over air pollution, forest cover, rivers, And these are, this is what I call judicial overreach. This kind of competence belongs to the executive branch, not to the judiciary. Okay, and so what the court has done is it has offered many pollution cases to the National Green Tribunal. Originally they were a little afraid that the National Green Tribunal would be competitive with them, but now they see the National Green Tribunal offers large damage awards using the civil law, and they are confined to the criminal law because the Air Act, the Water Act, and the Environmental Protection Act of 1986 are all related to the criminal law. So they're typically offer trivial fines, which are not very helpful. They are happy to let the NGT take this. The burden of proof in an NGT case is preponderance of the evidence. The burden of proof in a criminal case is beyond a reasonable doubt, much harder to do, and they have left all of this to the NGT, which has resulted in many large damage awards and less pollution for the whole country. I've noticed that the Supreme Court of India likes to use the expressions that have become popular elsewhere in the world. The public trust doctrine, which was developed by the Romans. Well, the public trust doctrine which in America applies to waters and land under the waters, and essentially that's it. In India, it's air and wildlife and protected lands of various kinds. They have just taken the public trust doctrine and extended it to a lot of different areas. They also like the precautionary principle, although for several judges, precautionary principle means take caution rather than act before all the evidence is in, because you might have irreversible damage. And they use intergenerational equity, usually appropriately. The polluter pays principle they use pretty regularly. Sustainable development they use often, but with an emphasis on development, not on sustainability. Development is the watchword in India. A high court judge said not very long ago, "Who am I to stand in the way of India's development?" High Court of Madras. Okay, question of whether, the last question, before I get to that, they are good on transgender. Recently, they've been quite good on the rights of a very small population, maybe a marginal population, nonetheless quite good. The transgender is recognized as a third gender. They're required in many jurisdictions to have their own bathrooms that have their own locks. So they're not involved with the issue of the bathrooms. They are, however, as you know, through Indian Penal Code section 377, they have criminalized homosexuality, and this is a stain on India. There are efforts to remove it. A parliamentary act would maybe be required, but the Modi government is not willing to come out on that side. So finally, I would say, is the Indian Supreme Court anti-poor? Well, we're not sure. If they go ahead with the Vedanta ruling and that thinking, they will not be. But typically, the Indian Supreme Court doesn't help landless, forest-dwelling, tribals, people. They're sort of helping their own people. They don't interfere in land conflicts much. They allow the Narmada, the main Narmada Dam, to reach its full height, even though a lot of people were displaced. A lot of tribals, and Adivasis, the scheduled castes, the untouchables. So I would say that the verdict is not in on that. It is possible that some leaders who will come up in the next few years will look at the Vedanta case and look at the Forest Rights Act of 2006 and look at the referendum provision unique in the world and maybe go ahead with that tradition, which would please their no longer alive brothers on the Supreme Court of India bench from the 1980s and 90s. Thank you.
Yeah, then I would suggest that we move on to Professor Vyasulu.
Khagesh, when he spoke to me about this particular seminar, very successfully conned me into accepting what seems to be a very dangerous mission. He told me to talk about some of my observations on this question of judicial overreach that Arvind just mentioned, not as a scholar, but maybe as an economist looking and getting puzzled as to what is going on. There's no doubt that the judicial overreach that Arvind has mentioned is a great reality. It comes in strange ways. One of the most recent things is the Supreme Court meddling in how the game of cricket is administered in this country. There's absolutely no particular reason for them to have got into that, but they have. And the way they do it makes it impossible for anybody to do anything about it, because they've set up a committee with the former Chief Justice of India, who's leading some kind of a charge. So it's one of those situations where they know exactly what is to be done and they're doing it, and that's that. But people like me who think that it could have been done in much simpler ways really have no voice anymore. But I want to go back to this. Khagesh asked me this because of a recent statement by our finance minister. When the courts were issuing some judgments that the finance minister did not like, and he thundered in parliament about the tyranny of the unelected in stopping what they wanted to do. Now it was a nice term, the tyranny of the unelected, and it's very rich coming as it did from the finance minister in an executive which has had no compunctions in overreaching on its side. At the time of independence, just after independence, when the constitution just became operational, there was a case on the freedom of speech, and the court ruled in favor of the freedom of speech. And the executive's response was to bring about a constitutional amendment within 1 year of the constitution coming into effect, putting reasonable limits on the freedom of speech. Now that's a very interesting kind of a situation. Whose overreach is it? And just shortly after that, there was an issue relating to acquisition of property and taking away property. And the courts again said, no, property is sacred, you can't do this. And property was taken out of the fundamental rights and made a statutory right. So it's the same executive that is now talking. I think the wheel has turned. But I want to share my puzzlement with you about certain other consequences of this so-called overreach by either side. I come from the state of Karnataka, and some of my examples will come from there. But the issues that we've been talking about, the issues of submersion of forest, hydroelectric dams, forest rights, all of these are very live in that state. It's a western state, and the Western Ghats are a repository of all kinds of diversity, which many of us would like to preserve, and many of these projects are not conducive to preserving such diversity. Now, one of the things that happens when we get a lot of one-stroke-plus politicians who become ministers and want to start doing things, when they're advised by the administration or civil servants, become abusive, they face false cases on them, they transfer them into insignificant jobs. There was a case where an officer objected to something, not objected, but advised a minister that something he wanted to do was against the law. And a week later, when his car was stolen, a suitcase of cash was found on it, and the corruption case was foisted. And so these are, I don't know, interesting tactics of dealing with good advice. Now, the result of this has been that the civil service, which is competent, fairly well educated and so on, has now decided that they will not give advice. So if a minister wants to do something that is patently illegal, they keep quiet or write on the files as ordered by the minister and things like that. And when I was talking to them later, they said, look, the courts will strike it down anyway. But this basically means that the normal structure of governance, in the day-to-day sense, is getting totally eroded, and that's not a good sign for a democracy. Because you're letting, yes, they're elected, but we have a great record in electing criminals. And letting them do what they want when it could be prevented through the use of good advice. The other point that I want to raise is that it's a job of the courts to give judgments. But what happens if those judgments are never implemented? We have for years had a law against bribe burning in this country. But just go to the burns ward of any hospital and see what's happening there. No, the law is there, the law is in place. The courts, when something went to them, have given the right kind of judgments. But why are the burns wards full of young women burnt up? So, there is this very serious question that comes up of the interaction between situations. And is this one reason why when people go to the courts, they ask for judicial intervention? I was part of a case where there were some issues about dams being built on the subsidiaries to the Ganges from Uttarakhand that join the river. And there were proposals to build hydroelectric dams in these areas so that they would generate electricity there, which would of course not be used in the hills but come down to the plains. And a colleague who's also an economist and I, when we sort of asked for the environmental assessment reports, he found some very interesting things in it. We found, for example, there is a provision for a public consultation when the proposal is mooted. And in this particular report it was said, no, this is being undertaken by the UP Hydroelectric Corporation, a government company in the public interest, therefore consultation is not needed. Nobody questioned it. It's a very interesting situation. And later on when we examined it, there are 4 of these tributaries to the Ganges that come there. And we found 4 dams were being proposed. And when we went through the environmental impact assessment, each one had been approved on the assumption it was the only one, not that there were 4 coming up. Now, and if the 4 did come up, there'd probably be no water to join the Ganges later. That's another. So, when we found all this, there's a whole coalition of people, retired general actually of the Indian Army, civil servants, academics like me, a whole lot of people got together and we filed one of these famous PILs. The prayer to the court was very simple. There is an Environmental Protection Act, there is the Forest Rights Act, and all we wanted the court to order the UP government to please prepare an environmental assessment report on the basis of the existing laws and not on statements like saying it's in the public interest. So this went to the NGT. The NGT issued summons to the UP government. UP government came, made all kinds of promises, assurances, and the project was clear. So where do we go? It's a very interesting kind. So what I want to flag is not this question of overreach. I also want to flag the fact that the executive functioning is getting eroded and is decaying because of some of the ways in which the politicians behave. That's one kind of issue. And the other one is that even when there are good judgments, very often they are not implemented in very, very critical areas. Now, if these are the kind of questions that become part of this JGLS partnership, I have a very different reason for hoping that it will succeed very well. Because to my way of thinking, that will be a very nice way of making America great again.
Okay. Yeah.
All right, thank you, Alex. I join everybody in the room that was thinking it's so nice to hear from professors on these issues, and thank you very much for the insights into what's happening in India. I'll just comment briefly from the point of view of a member of the court who was a community activist for a long time and for over a decade sued government. So that implies two things. If you sue government, it means you're not happy with what government's doing, but you think you have hope with the courts. And like Professor Vyasu said, I think that if you're going to be a lawyer, you have to have hope that you're going to get a good result. It's possible. Now, it depends what area you litigate in. If you are going to be a criminal lawyer, generally speaking, if you're a defense lawyer and you go to court, the concept is that you have to assume in large part that the rulings are going to be against you by the court. But you only assume that in your preparation. It is possible that you will get a result that's consistent with the law. And I'll conclude by bringing up this climate change obsession that I have. Okay, so hearing what Professor Rosencrantz had to say, and the kind of personal experience that Professor Vyasu has had, what do you think is going to happen with the men and women that are judges in terms of policy making that have to deal with climate change? They're going to go to the law first, and if they're good judges, then it'll be easy. If they're straightforward analyses, like you have to do an environmental impact statement, you'll require that. But in the margins, if you don't have the hard legal principles, such as at a certain point in the regulations, a chemical is life-threatening, but you've got a more soft analysis, like what constitutes, as Justice McKenna was describing, equal protection. Is it really equal protection if you have schools with different races going? Those are soft analyses. And when you consider, as I address again the young leaders and our young law professors in large part, who your judges are going to be, keep in mind that, of course, the judicial structure generally comes from lawyers who serve the power structure. But when they become judges, they have a certain sense of duty, and they can change, and our history is full of lots of examples. On the other hand, it makes a difference if you've got a community movement, because that empowers judges. And we have a community movement in the world at large to try to get courts and governments to pay attention to climate change, and there are statutes such as the one in Hawaii that says we're supposed to be, by the year 2045, dependent only on non-fossil fuel for energy. Those statutes can be produced. So it makes sense to look at where your judge comes from, but don't give up. Because there is an attitude that comes from any job you take, an attitude. I mean, if as a professor, it's so exciting because your attitude as a professor is to try to tell the truth about what's happened and maybe encourage young lawyers in their direction of doing the right thing. But as a judge, your attitude is, yes, you're supposed to be judicially independent. If you stray too far and overreach, as Armin has described, then you can compromise the integrity of the court. But let me conclude by asking, how often do you see judicial independence? Where the judge decides to do something that the law requires that means the judge isn't going to have a job anymore. So overreaching, to some extent, implies that you've got some judicial independence, and how valuable is that compared to the tradition as a judge of essentially reading the law in favor of the status quo. I'm sorry to conclude on something that provocative, but it's not as provocative as what Armin had to say, so thank you.
Okay, well, thank you so much to all our speakers. I've been told that all in all, we can have the room until 1:15. Yeah, since we are running a little bit behind in terms of time. So my question would be whether we should have a Q&A immediately now after the talks, or whether we have a break and have an overall Q&A session after because we only will have very short presentations. Yeah? So,
You tend to lose about a third of the people at a break, so I would say you're right.
yeah, we have the Q&A. Yeah, okay. And I especially invite students to take this opportunity to ask the questions that have come to your mind during this panel.